Joining you from Sydney Law School, which might be why we're not in our usual setup, but we're hoping that this will still be a good webinar. So firstly, I'd like to acknowledge the Gadigal of the Eora Nation, who are the traditional custodians of the land that we're on today, and pay my respects to their past, present and emerging leaders. And I extend this respect to all Aboriginal and Torres Strait Islander peoples joining us today as well. So today's session will be split into 3 parts. For the first part, I will quickly run you through who the ALACC is, what we do, and what we're currently working on. And then I'll also give you a quick overview of the key copyright considerations that you need to know in your role as an archivist or working in an archival organisation. And then I will hand you over to Elliot, who will look at some of the current reform reviews or processes that are underway in Australia. And after that, we will have time for questions. So just pop all your questions as we go in the Q&A, and that's when we'll do all the questions then. Okay, so what the Australian Libraries and Archives Copyright Coalition does. We call it ALACC for short. Some people call it ALACC. For me, ALACC just rolls off the tongue, easy. So what do? We advocate for copyright law reform in the interests of Australian libraries, archives and information providers. And we've been running for over 20 years. We offer informed contributions to domestic and international copyright law and policy discussions, and we meet regularly with the key contacts within Parliament to ensure that they understand our position or the position of libraries and archives and what our issues and concerns are around copyright. We also organise copyright education, including training and online resources as well, targeted at the library and archive sectors. And we support a balanced framework that protects the interests of copyright holders while ensuring equitable access to content for the public's benefit. So membership of the ALACC is made up of 10 member organisations shown on the screen, which includes the Australian Society of Archivists. The committee is made up of a chair and then 7 other representatives, and we meet regularly. So currently we are working in 3 areas. So that's advocacy, training and governance. In terms of advocacy, this year we've been heavily involved in ministerial copyright reform roundtables facilitated by the Attorney General's Department. So Elliot will talk about these later on in the talk. As part of my role, I'm also a member of the IFLA, International Federation of Library and Information Associations. I think that is the correct acronym. I'm a member of the IFLA Copyright Advisory and Other Legal Matters group, and I actually represent all of Australia, so on behalf of libraries and archives. So I take the Australian concerns to this group, and we meet in an international setting. And this year I'll be going to Rotterdam to attend the World Library and Information Congress, and at that we will also have like an advisory group meeting there as well, and we will also be giving some talks on copyright too. So that will be exciting, and I'll be able to share some Australian perspectives and also bring back some international perspectives as well. We are also writing submissions on topics such as AI. Elliot is writing a very detailed submission on AI at the moment, which is from the Ed Husick's department, which I do forget. Department of Innovation. So that is a big part of our role, is we send a lot of letters to ministers, to key MPs in the area. We would like to tell people just the key issues and try and get them on board so they're aware of this, and hopefully they can help us and support us. We also have some upcoming training sessions in Perth. So these will be in-person full-day sessions in Perth, Adelaide, Cairns, And we're also hoping to have some online sessions, so these will be more in depth. This session is just I would say just a very quick overview of copyright, and just a rundown of what we do and who we are, and just giving you a bit more information. But we are offering more in-depth training if that's what you're after. In addition to the training that we're doing this year, we will also be developing some online modules that will be specifically for the ASA, and they'll be hosted on the ASA members website, I believe. So keep an eye out for that. And we'd love some input into those training sessions as well that would help you get the most out of them. And in terms of governance, the committee and myself are working on updating policies and procedures, making sure that the organisation is running smoothly. So this is just a very quick guide to copyright, just to warm us up for today. We will share more resources where you can get more information about things, and feel free to put questions as well in the chat too. So what is copyright? These are kind of the main things to know about copyright. In Australia, it's governed by the Copyright Act 1968. Copyright is a legal right and it arises automatically, so you don't need to register it. And an idea that you have is not protected. It must be, in order to have copyright, it must be a physical expression of your idea. And copyright also protects the creator's moral rights. So that includes the right to attribution and protects against derogatory uses of the work. And copyright applies to a lot, probably most of the material found in an archive or a library collection. So it's an important part of the work that you do, and it's important to have an understanding of how it affects the collections that you work with. And in addition to this, a work can be made up of many layers of copyright, which we will have a look at now. So what does copyright apply to? As you can see, it covers a broad range of materials. So we have literary works. That includes manuscripts, pamphlets, lyrics, software code, poems, dramatic works. That includes things like plays, radio and television scripts, musical works. That includes the musical scores and the arrangements. So the lyrics would be a literary work. So that's, as you can see there, there's already 2 layers in a musical work, or in a song, a sound recording. Artistic work is made up, an artistic work, this covers paintings, artworks, photographs, sculptures, wallpaper designs, and it also includes works of artistic craftsmanship. So for example, that would be like a hand knitted jersey or handmade furniture or something that has been handcrafted. Copyright also applies to films, sound recordings, published editions of a work. So that covers typographical arrangements and the page layout of a book or a work. And broadcasts, so that applies to a radio or a television broadcast. So things that are also created by the Crown are covered by copyright, and we refer to this as Crown copyright. So that's any original works, sound recordings or films that are made by the state, made under the direction or control of the state, or first published in Australia by the state. So you probably will have some of this material in your collections as well. So the duration of copyright is long for most material. And for example, works, so for example, like an artistic work would be protected for the life of the creator and then 70 years after they die. So it's quite a long time. So after that 70 years is up, that work enters the public domain, and that means there's no copyright and you can use it for whatever purpose. If a work is still in copyright and it's still within those 70 years, or the creator is still alive, to use a work, in many cases, you will need to get permission, but you may be able to rely on an exception in the Copyright Act, which we will look at shortly. So I just quickly spoke about Crown copyright. One of the exceptions to duration is Crown copyright, which lasts for 50 years from the first date that it was made. If you're interested in, say, a specific type of material that you have and you'd like to know the duration, there is a really good table of duration on the Attorney General's website. So if you just Google search copyright duration table, that should come up. I think we also link to it on our website as well. But that actually has a lot of different scenarios around different types of material and when the copyright would lapse for that material. And it's very specific. So I do recommend checking that out. But in general, copyright lasts for the life of the creator and 70 years. So if you can remember that, that's probably a good place to start. So in terms of copyright ownership, the person who created copyright material is the first owner, in most cases, is the first owner of copyright in their work. There are some examples where that may not be the case. So if you create copyright material as an employee, sometimes the employer can own your work, either through the legislation or through your employment contract as well. There may be a clause in there that says your employer owns copyright. There's also commissioned work. So that's when you pay someone to create a work. And in most cases, the commissioner usually owns the copyright. So there's provision in the Act specifically which relates to portraits. So if you commission a portrait, the person that commissioned the work owns the copyright. But typically contracts where you are, it's a contract for service, so you've got your artwork or you've got a work that needs to be created, that contract will lay out the copyright terms and conditions and who owns the copyright of that work that's created. So in terms of an institution or a person purchasing a physical work, for example, a painting, copyright remains with the creator of the copyright material, unless, for example, it was a commissioned work or made through your employment. So the person that created the work retains the copyright, even if someone buys the physical painting. So that could be an institution or a person, but it can be assigned to another person or an institution. So you could have a license agreement which says you're buying the work, but I'm also transferring ownership of copyright to you, or I'm licensing out, the use of the work in some cases as well. And in terms of what happens after someone does die, and then there's that 70-year period of when that work is still in copyright, copyright is passed down to beneficiaries of an estate upon the death of a creator. So that can cause a few problems because it's automatic. It's not usually written in someone's will that this copyright is being passed down. So that can cause problems when you're trying to find someone later. And in a lot of cases, the next of kin may not even know that they own the copyright of the work as well. So we use this term quite a lot, orphan work, and in library and archive collections, you will come across a lot of orphan works. So this is where if the author of a work is unknown or untraceable after a reasonably diligent search, then you would classify that work as an orphan work. And in terms of a reasonably diligent search, that could be sometimes found in your organisational policies and procedures. So your organisation may have something that refers to the use of orphan works and what a reasonably diligent search standard looks like at your organisation. If you don't have any guidelines, you can check out the NASLA guidelines on due diligence searching in orphan works. And also there's takedown procedures and notices as well. So there's things that you can rely on, but it really depends on your appetite for risk and your organisation's procedures around that. In addition to the reasonably diligent search, You also have section 200AB, which allows archives to digitise and share orphan works if certain criteria are met. Again, we would get you to just refer to your organisational policies and procedures around that. If you need more information, we do have, we've got a whole booklet on section 200AB on our website, which I'll share in a minute, which has a lot more information about it. So orphan works is important because this is something that comes up in the reform process as well, which Elliot will talk about later. So moving on to exceptions. So in the Copyright Act, there are specific exceptions for libraries and archives. So the main ones are document delivery. So an archive can provide material for research and study, but this does not extend to audiovisual materials. And it's purely just for the purposes of research and study. Interlibrary loan, you can provide other libraries or archives material for their clients or for inclusion in their collections. Preservation, you can use this exception to make any use of material necessary to preserve material in a collection. For example, if a work was at risk of degradation or there was a fire or a flood and you needed to replace a work in your collection, you can ask another library to make a copy for you. Another exception is on-site research. So you can make available original collection material on site, as long as the research is being carried out on site at the library. So assisting persons with a disability. So you can, again, this exception allows you to make any use of material within the collections to provide access to people with a disability. And administration of the collection, you can make any use of material for the care or control of your collection as well. So publication of unpublished works, you can reproduce, communicate certain unpublished material for research and study. And as I mentioned before, the flexible dealing, section 200AB, allows you to make use of any material for certain socially beneficial purposes. So alongside the exceptions that are just specific to library and archives, we have fair dealing exceptions, which can be used by anybody. So these include fair dealing for the purpose of research and study, parody and satire, criticism and review, and fair dealing for disability access. So this is just a very quick summary. Most of your material in your collections will be subject to copyright. Copyright lasts for a very long time, from the death of the creator and then 70 years. But there are exceptions within the Copyright Act that allow archives to use material for certain uses, and you can also ask permission as well. A licensing agreement, find the copyright owner and ask them permission to use the material. So with that, I'm just going to hand you over to Elliot, and we will have time for questions afterwards. Thank you.
Excellent. Thank you, Sarah. So now that Sarah's given us an overview of the copyright system and in particular how it applies for archivists and other information professionals, it's good to also give you a bit of an update on where the copyright reform process is at. So I'm going to talk a little bit about that, but I guess the kind of context to start any conversation about copyright reform is that it can be a really difficult thing to achieve, because often it's really difficult to get the general public interested in conversations about copyright. Partly, because they often have more interesting things to think about in their life, but also because the process of reforming copyright takes a really long time as a general rule. Law reform is a lengthy process anyway. Complicated areas of law that require specialist skills and knowledge, like copyright, tend to take an even longer period of time, particularly where there are lots of stakeholders, where there may be different opinions or ideas about what the right way forward for copyright is. We can end up in quite a lengthy process for trying to make changes to the copyright law in a given country. And so with that in mind, recent periods have been a little bit uncharacteristic in terms of copyright reform, because we have actually seen quite a lot of copyright reform in recent years, and we are still undergoing a reform process at the moment. So I'll give you a bit of an overview of some of the recent reform that's happened, and then I'll talk a bit more about the reform process that's still in play. So in recent periods, we saw the passing of the Copyright Amendment Disability and Other Measures Act in 2017, which introduced, firstly, Australia's implementation of the Marrakesh Treaty, which is a treaty for access for people with vision impairment. And in the Australian context, we took up that international treaty and ratified it, brought it into Australian law. But in particular, in doing so, we went beyond the scope of the treaty itself and actually applied our disability provisions in terms of copyright access to any form of disability. So we rely now on the definition of disability in the Disability Discrimination Act, which means that we actually apply it well beyond vision impairment. We apply it to any form of disability, including temporary disability. Now, within that same legislative instrument, we also saw a range of other changes, which is why it says other measures. And this included a lot of attempts to simplify and streamline parts of the Act. In particular, it saw some overhaul of library and archive exceptions, particularly things like the preservation exceptions. But it saw some wide-ranging attempts to simplify how the Copyright Act works. So it also changed some of the rules around particularly things like copyright duration. So it introduced a copyright duration for unpublished works, which was an important thing. It may not seem like a particularly big thing, but it's very important, particularly for players like archives, because it meant huge swaths of material that had historically been left in essentially a kind of copyright perpetuity, now were able to be used because that material had a duration at which it would pass into the public domain. So that kind of change to the Act really increased the volume of material that might be reusable to the public within cultural collections like archives. As I said, there was a number of simplification and streamlining provisions, particularly around the libraries and archives exceptions. Kind of sitting alongside this or happening in close proximity to the Disability and Other Measures Act, we also saw the grandfathering or sunsetting of the previous copyright regulations. We saw the introduction of a new set of Copyright Regulations 2017. It was quite technical and was introducing a number of the kind of extensions to these simplifications. Nothing too major to say out of that, but really its intention was about modernising and updating the copyright regulations. And then also in 2018, we saw the passing of the Copyright Amendment Service Providers Act, which basically extended the existing safe harbour scheme, which had applied to what's called a carriage service provider or an internet service provider. It extended that scheme to other types of players, such as libraries, archives, education providers, and some other not-for-profits. So the safe harbour scheme was basically a process through which an organisation providing certain types of services like access to the internet could, as long as they followed certain steps, limit their exposure to liability for the actions of their users. So if somebody was using internet at a library or an archive and infringing copyright in the process of using that internet connection, then it gave opportunities for those organisations to limit their exposure to risk as a result of their users' actions, as long as they were following a procedure that's set out in the Copyright Act. So quite recently, we also saw the release of an exposure draft for a proposed amendment to the Copyright Act, the Copyright Amendment Access Reform Bill. in 2021, and it introduced not just a kind of draft or written version of potential provisions of the Act, but a lot of detail about how those provisions would work. And so that in particular included a range of reform options or ideas that were put on the table, one of which was the proposal to introduce a limited liability scheme for the use of orphan materials. So basically where somebody had followed requirements like doing a reasonably diligent search, they might be able to make use of orphan material with a limited risk of exposure for having made that use. And in particular, it set out things like rules for what would happen if a copyright owner came forward in the future, etc. There was also a proposal to add a new fair dealing to the fair dealing exceptions, in particular a fair dealing for the purposes of quotation of copyright material. While we had some concerns about the scope of how that provision would work based on the drafting, overall we were really supportive of the introduction of a provision for the purposes of quotation, because it is quotation is an activity that is seen by generally by the public as being an acceptable activity, and it's currently not within scope of the Copyright Act. There was a proposal to also do further simplification of the Libraries and Archives exception, and also to extend the Libraries and Archives exceptions into other areas, in particular introducing some situations where private and personal use of material from a cultural collection was permissible, which is currently outside of scope in terms of the exceptions as they apply. There was also moves to modernise and update the educational provisions and the government provisions, and in particular, not just the exceptions within the Act, but also the associated statutory licensing schemes that apply to the educational and government context. So there was quite a lot of things in that, that proposal. Of course, because of a change of government after an election, that exposure draft was abandoned. And so we're not kind of proceeding with the drafting of that. However, there are some topics that were part of that reform process that have carried through into where the copyright reform activity currently sits. So post-election, we've seen the incoming government continue to investigate copyright reform opportunities. As I said, they aren't proceeding with the drafting of the access reforms exposure draft, but they are looking at a number of the topics that were included within the scope of that proposed legislative reform. So in particular, Minister Dreyfus has instituted a national ministerial roundtable on copyright, which is looking at a whole range of different issues. So there are a number of different issues, and some of these have already been taken up in roundtable meetings. Others of them will come up soon in terms of that roundtable and its discussion points. So it's looking at things such as orphan works and what might be a mechanism moving forward for the productive reuse of orphan material. There's also been discussions on quotation and what might be a mechanism for proceeding towards an exception for quotation. So there was a ministerial roundtable in February, I believe it was, which Sarah attended on behalf of the ALACC and the ADA.
In June.
And June, there's been two of them already, looking at particularly the question of orphan works in quotation. There's going to be a future roundtable looking at the kinds of copyright concerns that come up in relation to remote learning, particularly, I guess, catalysed by the experiences of the education sector in trying to continue teaching during the COVID-19 pandemic, of course, ongoing pandemic, but certainly the conditions of that pandemic have changed and a lot of in-person learning has returned, but it still raises important questions for what happens when learning is taken into an online environment, which changes the nature of copyright in that context. So I saw somebody in the chat asked a question about AI, and certainly we can have a chat about that in the questions, but I will say that it is actually one of the interest areas or priority areas for the Ministerial Roundtable instituted by Minister Dreyfus. And so there is an upcoming roundtable looking at AI and the definition of broadcast in the Copyright Act. And that's slated to occur in Canberra on the 28th and 29th of August. And the ALACC and the ADA will be represented at that roundtable to continue discussions around reform in these key areas. So while we may not have seen the access reform drafting proceed, a number of the topics and some new emerging topics have also carried forward into the current reform process. So this is a kind of live reform process. It's currently running. And so it's a really good opportunity for us to learn more about the sorts of experiences, the types of things that you're incurring, as information professionals, as archivists, which might help inform the reform approach that we take forward through these roundtables. So before we move into questions, I'll also just remind you, of course, that there is a dearth of copyright resources available on the ALACC website, covering all manner of questions that you might have about copyright. So it's a really good location to go to as a kind of first point if you're looking for information on a particular topic about copyright, but certainly through forums like this, through our training, and even through our online contact form, we're always available to answer questions about copyright that you might have. So thank you for sticking through this lunchtime session on copyright.